West Legal Ed Center and Celeste Attorneys Ed Center would like to welcome you to today's program, Avoiding Discipline at the USPTO, Recent Developments in Patent and Trademark Ethics. Please submit questions by using the Participation tab located under your viewer window. The program materials can be found under the Supplements tab. It's now my pleasure to turn things over to our speaker, Emil Ali, for further introductions and to start the program. Emil?
Thank you so much. Today we're here to talk about avoiding discipline at the USPTO, recent developments in patent and trademark ethics. As mentioned, I'm your host, Emil Ali, and a little bit of background about me. I am a registered patent attorney, but I focus my practice on the intersection of ethics and IP. So I help patent agents, patent lawyers, and trademark lawyers basically understand the rules of professional conduct and deal with everything from lateral transitions to disciplinary defense, and of course, help them navigate the construct of the various conduct rules, including things like subject matter conflicts. So 60 minutes sounds like a lot of time, but I will tell you it is not. So I'm going to tell you that I'll try to go through things quickly. I encourage you, if you have questions, to ask them in the chat, and I will try to answer them with as much context as you provide to me. But first off, why is IP ethics very different than traditional ethics? Well, first off, it's really important to understand that there are special conduct rules that apply to those who practice before the USPTO. Whether you're filing a patent application, filing a trademark application, or litigating before the USPTO, you are engaging in practice before the USPTO that is subject to the USPTO rules of professional conduct, as well as substantive rules. For example, when you appear in federal court, you are subject to things like Rule 11, and you are subject to the rules of professional conduct in that district or potentially in that state. However, when you appear before the USPTO, you might be subject to your state bar rules. You may also be subject to a version of Rule 11, even in a non-litigation setting. That's 37 CFR 1118. And then you might also be subject to special duty of disclosure obligations. For example, on the patent side, because it's considered an ex parte matter where the patent examiner is not really acting as your opposing counsel, but almost like a judge, you have a special duty of disclosure obligation to the USPTO. And a failure to comport your conduct to that duty of disclosure obligation could result in unenforceability of the patent application, discipline by the USPTO, and of course, a finding of inequitable conduct. So with that, I want to talk to you a little bit about an outline of what I want to discuss with you. First, we're going to talk about the regulatory power. I know I gave you a slight introduction, but for those of you that are not familiar with the USPTO's ethics rules, I'll tell you about how they work and what the federal government provided to the USPTO by way of authority. We'll talk about the nitty-gritties of conflicts of interest in IP representation. For example, we'll talk about subject matter conflicts. We'll also talk about the attorney-client relationship and how that might be different for patent attorneys and trademark attorneys, especially, for example, when they're working with foreign associates. That's a very unique area of practice that is very common in IP practice, but maybe not as common in other sort of relationships. And then we'll try to close it out with some best practices to mitigate ethics risks and avoid professional discipline. And I will just start out by saying it is somewhat of a salacious title. Not very many people are disciplined by the USPTO or state bars, for that matter, with respect to IP representation. Out of almost 50,000 patent attorneys out there, trademark attorneys is very difficult to quantify. There's only a few hundred ethics cases opened by the USPTO each year. And it's important to know that there are often times when people make mistakes. And, I think the USPTO understands many of those mistakes. But these step-by-step types of topics that we're going to talk about are really brought up to help you better understand your obligations to not even get before the USPTO's Office of Enrollment and Discipline or the various state bars. So let's start out with the regulatory power. So the the practice before federal agencies, for example, the SEC, the FTC, maybe DOJ, it's all done by what we call the Administrative Procedure Act. It stands for the proposition that anyone licensed in any state or territory, including the District of Columbia, can represent others before any federal agency. Okay, so that means I, sitting in California, even though I'm admitted in DC, can practice before the federal government's office in New York, right? It doesn't matter that I'm not admitted to practice in New York. If I am practicing before a federal agency, I can do so under the Administrative Procedure Act. I'm not required to go become a member of the New York Bar just to represent somebody before, some federal agency. However, the USPTO was given extra authorization to regulate the conduct of people practicing before it, including special conduct for those who engage in patent matters before the USPTO. They've also been given special authority by statute to suspend or exclude folks that violate those prohibitions or the regulations under 35 USC 2B 2D. It doesn't mean that other agencies cannot do so, but the USPTO was just given special authority to do so. So who are these practitioners? Well, if you look at the USPTO rules of professional conduct, they, instead of saying lawyer, right? Lawyer shall not do this, a lawyer shall, it says practitioners. And that's key because the USPTO includes non-lawyers as those who are practicing law and authorized to practice for the USPTO in patent matters, right? You, generally speaking, you have to be a lawyer to practice in trademark matters, but practitioners as a definitional element includes registered patent attorneys and patent agents, includes trademark attorneys, those who have been granted limited recognition, and that could be, for example, people in the law school clinic program, as well as those who are non-citizens, so non-immigrant aliens, and then, of course, Canadian agents who are provided reciprocal recognition are also considered practitioners subject to the USPTO rules of professional conduct. So if anyone has ever heard me speak before, I often talk about this butt in seat rule. It's this rule that's really in every state and other jurisdiction outside the USPTO. That's how they regulate the practice of law, between the borders physically. Well, the USPTO doesn't have borders, right? It doesn't matter if you're practicing from California, from Nevada, from New York, from Canada, from Mexico, you're still practicing before the USPTO. So what constitutes practice before the USPTO? Well, 11.5 is a great read because it seems to encompass anything. And so far, I have not seen that litigated. And I expect at some point in the future, it will be litigated because it's very broad. Basically, what the USPTO says, any law-related service related to patent practice or trademark practice, obviously drafting patent applications, prosecuting patent applications, but even advice in contemplation of filing a patent or trademark application. And let me hold on for a second. So for those of you that are patent and trademark attorneys, you may say, oh, well, that makes sense. But imagine if one of your colleagues at your law firm or somewhere else says, hey, you should talk to my buddy so-and-so. He or she can help you file a patent application. And then the client says, well, what's the difference between a patent application, trademark application, and which one is better for me? And you say, hey, I'm not a patent attorney, but I think in your case, because you're not, protecting a trade name or brand, you're protecting really the utility of something. I think a utility patent application, the way the function and way something works is more appropriate for you. So why don't you talk to him or her about obtaining a patent application? That advice in contemplation of filing a patent application could cause your colleague or friend to engage in the unlawful or unauthorized practice of law before the USPTO. And that creates a little bit of a kind of a indication that maybe this rule is slightly too broad. Regardless, obviously, it also includes holding yourself out as authorized when you are not authorized to do so. So 11.5 is, again, a very, very broad rule and covers a lot of what practice before the office is. But while we're talking about practice before the office, I want to talk about the assistance of non-practitioners. So first of all, you are specifically under the rule allowed to work with non-lawyers, right? You can work with paralegals, legal assistants, etc., as long as they're under your supervision. So, the patent attorney that uses a technical specialist or the trademark attorney that uses a paralegal to help fill out forms, totally legitimate and might be a competence issue if you're not using one, right? Sometimes it's appropriate, sometimes it's not. It really depends on the circumstances. But why is this assistance of non-practitioners important? Well, it's because the USPTO has been very critical about certain people's use of non-practitioners and the supervision requirements thereunder. So let's move to what those supervision requirements are. So supervision is kind of a very broad term, right? So what should we think of when we think of supervision? Well, first, I think we need to look at the rules regarding supervision. And there are specific delineated rules about that. Under Model Rule 5.1 to 5.3, which is similar to 37 CFR 11.501 and 11.503. The USPTO rules require attorneys that are in a position of power to essentially make sure that those underneath them have reasonable measures to ensure their conduct comports to the appropriate rules. And obviously that includes both people in management authority as well as supervisors. And obviously, if you're aware of some sort of conduct that's being done inappropriately, that you must make sure that you try to fix that problem and don't otherwise take it over, essentially make it your own. But what about the subordinate practitioners? Well, subordinate practitioners could be, it could be you could be in a position where a partner or somebody more senior to you tells you to do something that is inappropriate. And the issue with the kind of understanding the nuance there is if it's a clear question of law or fact that's, hey, my supervisor lied to the judge or hid this reference, you have a duty to extricate yourself from that situation, including potentially reporting the conduct. However, if it's a question of kind of minor judgment, you're like, hey, it's unclear, you can follow the steps that your supervisor took. But going back to non-practitioner conduct, well, that too can become your responsibility as an attorney or managing attorney, et cetera, if you engage in some sort of, or they engage in some sort of conduct that is clear was not based on any sort of supervision, right? A lack of supervision could cause you to have some responsibility for their conduct. So how do we make sure that as lawyers, whether we're a junior lawyer or a senior lawyer, that we make sure that our conduct does not impact the rules of professional conduct? Well, one, when it comes to supervision, whether you are dealing with other lawyers or non-lawyers, I want to have standard operating procedures. What is always difficult for me is when a lawyer says, well, my paralegal made a mistake and they weren't supposed to do this. And the paralegal says, well, my attorney told me to do it. And I say, okay, well, it's your word against theirs. And now we have an investigation. How can we resolve this issue? And the ultimate answer is, well, there was this document, but we never formalized it. Well, if only you had that standard operating procedure that we could show to the USPTO or to the bar, say, this was an isolated mistake. Here are the reasonable procedures that this lawyer or this law firm put into place to make sure these problems did not occur. Another is having training, right? Training for lawyers, training for non-lawyers, both substantive and in terms of things like legal ethics. If the non-lawyer doesn't know the established rules of professional conduct, how can you expect them to make sure that their conduct comports the rules? And that's why it is really important. If you look at large law firms, one of the things that they often have are kind of normalized ethics, CLEs, et cetera, at their office. And that's not because they want to just have a bunch of training. It's because it helps them coordinate their compliance with, for example, Rule 5.1 and the rules applicable to the rest of the team. And then, of course, hiring practices and employee agreements go hand in hand, right? You want to start with a really good foundation of what expectations are, right? Everything from the job posting to the interview process and the questions that are asked of the people, right? You want people to work independently, but you also want them to make sure that they're not working so independently that you're not having a keen eye on what is going on. And that brings us to a chain of command. I want to see that lawyers are properly instructing their team about other lawyers beneath them, as well as non-lawyers, whether it's a file clerk, legal assistant, paralegal, but where they're supposed to get their questions asked. It shouldn't necessarily be, oh, well, the legal assistant has to ask the paralegal who has to ask the head paralegal. There should be a dotted line to an attorney that's going to help answer those questions in an appropriate fashion, right? They should know that the person that makes the decision is the attorney. Obviously, it's a very, very delicate situation because you also want the paralegal to take some ownership of the responsibility, but also not be bothered by every small little thing. But it is important to have that chain of command. And also, whenever you have any sort of written materials, whether it's practices and procedures, et cetera, you want to make sure that those things are reviewed. But beyond those, how do you as a lawyer or manager make sure that things are being done correctly? Well, to prove supervision, you want to prove that the things that were not run by you. Let's say, for example, there are notices being sent out about maintenance fees for granted patents. Well, let's make sure those emails are going out. Maybe do a periodic file review, hopefully of all files, but if not, at least a sampling of those files to make sure these communications are being done correctly and in a timely fashion. That's not only an ethics issue, but just risk mitigation from a malpractice perspective. And then, of course, employee reviews. That is so important, right? I think it's very important to make sure that non-lawyers and lawyers alike know where they stand in a specific situation. And the best way to do so is to make sure that they're aware of the pros and cons of everything that they're doing. I'm not saying, inform everyone right away, hey, you're doing a bad job, but say, listen, it's been 3 months. I want to take this opportunity to explain to you that here are areas of concern that we have, and here's how I would like to train you or help you get assistance in moving forward. And of course, a shout out to myself, somebody like me. I'm ethics counsel. I work with law firms on these issues, right? We do the trainings, we do answer the questions to make sure things are being done appropriately. So what could happen? Well, if you are in a relationship with a paralegal who, for example, is not doing things appropriately, here are some examples of how that could arise. Well, one, the paralegal is engaging in legal practice. So this is something that I often see all the time, and it's the paralegal that is trying to be too helpful. And again, I love self-started people, right? Self-starters, highly motivated people that are talking to a client and saying, you know what, I saw that you sent in a specimen. I looked at it, and before I sent it to the attorney, I just wanted to tell you that it's not suitable. Sounds nice, but are they giving legal advice, right? And what about an IDS prepared by a non-practitioner? Well, I don't think that preparing an IDS itself is problematic, but submitting it without attorney review would probably be. And then, of course, having problems is common, right? We all have mistakes and problems that we deal with. The question is, if you have repeated violations, that can be a problem, right? So an error one time, even if it costs millions of dollars, a mistake, whatever it might be, not a big deal. But it's a systematic or systemic problem that could be extremely problematic. And I do want to take a moment to kind of just make sure everyone's aware of malpractice versus ethics, right? Malpractice is this idea that a client can say, I lost XYZ because my attorney failed to do Y. And because they failed to do Y, I can prove causation and damages, and therefore get some money from my lawyer, former lawyer, and maybe through the insurance company. A disciplinary complaint sometimes comes hand in hand, or sometimes a malpractice complaint leads to disciplinary complaint and vice versa. But disciplinary complaint is this idea that a complaint from a client, judge, whatever, could impact your ability to practice law. Either, usually starts with an investigation, but could end in a warning letter, closure letter, reprimand, suspension, or even a disbarment or exclusion from practice. And obviously that's one of the worst case scenario. But those are kind of the two major differences. It is really important to manage both. And a lot of times following the ethics rules will help you avoid these malpractice issues. So moving on to conflicts of interest. So if I had to say, 3 points about conflicts of interest, they are: one, conflicts are, conflicts are everywhere. 2, clients will often sign waivers. And 3, a waiver requires informed consent. And this is not verbatim from the rule. This is just my experience with helping clients understand conflicts of interest, is that, one, a lot of lawyers will say, well, I don't engage in conflicts because I, don't deal with them. Potentially possible, but highly unlikely. Why? Because when you're an expert in your field, it is very possible that you will often have individuals, companies, et cetera, come to you for your expertise. If they're coming to you for your expertise, it is very likely that they may be in fields that are similar to others and may involve things, especially in the patent field, that are subject matter conflicts, even in the trademark field, likelihood of confusion. But the second point is very key. So I usually change some hearts and minds when I say the conflicts are everywhere, because everyone says we can avoid them. But what I tell people is you can't always avoid them, but you can often get waivers signed by the client, right? Many people are too scared to ask, but they are very, very common. Many, especially sophisticated clients, are used to signing waivers. But the really important piece is a waiver requires informed consent. A lot of attorneys that I've dealt with say, well, if I just do X, Y, and Z, if I just, get rid of this client, if I, do that, can I just fix the problem and not inform? I think that is itself the conflict. The idea that you want to avoid telling a client about a conflict is itself the conflict. So it is really, really important to think about those things, because if you engage in some sort of conduct that involves a conflict of interest and don't get an appropriate waiver if it was foreseeable, you could have ethics, malpractice, disqualification, or reputational or optical harm. So moving on into a deep dive into conflicts, I think it's really helpful to understand, and I apologize if many of you are already aware of this, but the basics of regular conflicts. So you need just one client relationship. You don't need two, just one. Then you need a representation of one client against something else, right? Against a third party, yourself, another client, former client, or a risk of being limited by any of those other people. So again, another client, former client, third party, or your own interest. It does not require any damages, harm, or improper conduct. It is strict liability. That is really, really important. And when I say think about the optics, what I'm talking about in the optics is sometimes we call them political conflicts. I usually call them optical conflicts, because imagine if you represent Google and, all of a sudden, they see a patent application with your name for the, Bing web search tool. That's their competitor. It may not be a conflict of interest, but it may be an optical conflict. It could rear its head as a conflict of interest because of Rule 56 and the like, but it may not be a traditional conflict of interest, but it may still impact your relationship with that client. As this is an ethics CLE, I do have to spend a moment just talking about some of the ethics rules. I do kind of reference them around, but I want to just give you a little bit of instruction about how these ethics rules apply. So we all know that, hopefully the folks that are listening to this CLE are patent attorneys or trademark attorneys, and they are subject to the USPTO rules of professional conduct, which are located at 37 CFR 11.101 et sec. And they are based upon the ABA model rules, which obviously form the basis of the conduct rules in pretty much every state and DC. So a good understanding of where to look when you're dealing with conflicts is an ABA model rule 1.7 applies to current client conflicts. 1.8 is kind of business transaction with clients. And if you're trying to figure out where to look at the USPTO rules, you would take, for example, 1.7 and punch in 37 CFR 11 dot and then 1 and then replace the period with a 0 and get 7. So it would be 11.107 is rule 1.7. So that's for current client conflicts and transactions with clients, et cetera. If you're dealing with a former client conflict, then you look at 11.109, which is ABA model rule 1.9. And then, of course, if you're talking about the imputation of client conflicts, we're going to look at rule 37 CFR 11.110. And then finally, we don't really talk about it here, but for government employment conflicts, whether it's current or former government employment, you're going to look at 37 CFR 11.111. So going to current client conflicts, I think this is a really helpful rule to look at because we're talking about what you're not allowed to do vis-a-vis another current client. So rule 1.7, as I talked about, 1.7A1 specifically, talks about the current client conflict relationship that we have. And what we're dealing with here is your inability to be directly adverse, both sides of the V. The classic one from law school was HVW, husband versus wife. We're not going to be on both sides of the V. Okay. I don't need to explain that much further. What I do want to explain is whether or not you can represent a client in a matter in which there's a material limitation to others or yourself. So in other words, is there something or a possibility that your representation, and when I say your, I'm talking about anyone within your firm, right? Because we're going to look at rule 1.10, the imputation of those conflicts. Well, it could be something like your prosecution of one application, or whether it's a patent application or trademark application. How would it impact or materially limit your representation of another client? That's going to be really, really important. So again, we're not going to be representing one versus another, but in a trademark application, for example, you're representing a client. Let's say you're representing Apple. So you're representing Apple in trademark matters. All of a sudden, another client comes to your firm and says, well, we want to file a trademark application for totally different technology. Let's say, even though it's descriptive, fruit, Apple for fruit. Well, now you have one client that may be impacted, right? It may not be adverse because they're both, one already has trademark protection, the other one is seeking trademark protection, but it could materially limit your obligations to both clients, right? Because one client is going to have one position, the other client is going to have another position. So that's an example of a current client conflict. But there are a lot of other types of conflicts that are also really important to be knowledgeable about. Business transaction with the client. Are you, taking an interest in a patent as all or part of your fee? Are you buying a house from your client, right? Those are all specialized. They're not necessarily IP specialized other than the taking an interest in a patent as part of your fee. Being a co-inventor, right? The gold standard, if you're a co-inventor, especially if you're a co-inventor after you receive the disclosure, is to assign it back to the client. You may have a duty under the law to create yourself as a co-inventor, but you don't have a duty to become an owner of the application. What about third-party payment for legal fees? That's a very common one. I actually did a CLE this morning about litigation funders, but also it comes through when you have insurance companies or you have somebody else, like maybe there's an inventor and the inventor has somebody else paying their fees. That could be something for you to consider. And then, of course, limitations of liability. Rule 1.8 prohibits prospectively limiting the liability for any sort of malpractice, et cetera, unless certain conditions are met. And that's obviously in many states. In some states, like California, it's generally prohibited in all but a few instances. Now that we've talked about kind of current client conflicts, we also want to talk about former client conflicts. Well, one, a lawyer cannot represent a client in a matter that's directly adverse to a former client, but only if the matters are the same or substantially related. So think about that for a second. You can't represent folks in matters when they're current clients if there's, the relationship is a lot more broad. Here, it has to be the same or substantially related. So, for example, if you are, engaged in some sort of conduct involving suing your former client on behalf of a current client, that may be okay as long as it's not the same or substantially related. Same is pretty easy to understand. Substantially related, very fact specific, right? In the disqualification standard is sometimes different than the ethical standard as well. The other major issue I want to talk about is subject matter conflicts. So assuming we understand the basics of conflicts of interest, I want to talk about subject matter conflicts because that's the highly specialized area of the law. So one, I think the first question is, are we in a zero-sum game? And unfortunately, I cannot answer that because I think it's a really difficult question. A lot of people compare patent law to getting a license from the federal government. That's where the case law that we look at is. We say the radio station analogy. A lawyer representing two different applicants for a radio license, it's not a zero-sum game because they can each get a radio license. Same thing with a patent. Two people in the same subject matter area could theoretically both get patent protection. Right? So when do two separate applicants have the similar or same invention? It's hard to tell, right? But a couple of things that we look at. One, we'll talk about economic competition in a second. But two, in terms of claim shaving is this idea that if they have a similar invention, maybe the lawyer will say, well, I don't want these to be cited against each other, so let me try to narrow the claims of each of those applications. Or if they are cited against each other, we have to distinguish them from each other. And I will distinguish them by saying that A's application was not covering what B is trying to do, essentially narrowing them. Even though the applicant didn't intend to try to, broaden them, we're trying to narrow them to make sure both get patent protection. And that may keep some clients happy, but it may not be appropriate in most situations. And so that's a really, really important thing to consider. So let's talk about the issue of whether or not economic competition is itself a problem. So let's say you represent LG and Samsung, right? Two people in the display industry, both in patent matters. Is that allowed? The off-the-cuff answer is yes. Why? Because Model Rule 1.7, Comment 6 says, simultaneous representation in unrelated matters of clients whose interests are only economically adverse, such as representation in unrelated litigation, does not ordinarily constitute a conflict of interest and thus may not require consent of the respective clients. But here's the area where you have to pause and think. Are they seeking coverage for the same technology area? Right? They're both in display technology. Okay. Well, is it likely that one application is going to be cited against the other? That is a key element here. Because once that happens, there's likely a conflict of interest requiring disclosure and waiver. The other issue is Rule 56. Is there something in Samsung's application that might need to be disclosed in LG's application and vice versa? And neither one of those are public. Then once you cite them, are you going to have to distinguish them? Whether or not it's because you cited them or because the patent office cited them, the examiner cited them, that may be very, very important. So I'm not saying that you should not represent folks here, but sometimes it's an area where you may want to get a proactive conflict waiver. But what about subject matter conflicts in, what's my take on them? Well, one, this is not a popular statement because a lot of people say, well, no, I couldn't see that in the future. Well, one, I think that you can usually see subject matter conflicts in the distance, right? There are some instances where they're not, but usually they can be seen. And, I think it's important to get waivers. I don't think that you can always get them at the outset. There are some special optical issues to consider, and advanced waivers are not always appropriate because an advanced waiver or any waiver needs informed consent. But let me explain to you why subject matter conflicts can arise and can be seen in the distance. When I gave the example of LG and Samsung, right? We know we have two clients in these technology areas. There's a potential likelihood that they will overlap. Another instance would be if we were representing LG in the display space and maybe Samsung in, some minor display issue, but only in vehicles. And maybe for whatever reason, it wasn't foreseeable, even though it might be the same R unit, et cetera. Those are areas where I could say, okay, well, it may not have been apparent to us, but having that done at the outset could be helpful because then you're not sharing confidential information just to get a conflict waiver. All you're saying is, hey, we have these applications. This is how we're dealing with them. We're going to have separate teams get informed consent. This is what the process would be to make sure that we don't leave any client in the lurch. So courts have not spoken on subject matter conflicts very heavily, but one of the biggest cases out there is Mailing v. Finnegan-Henderson. And many of you in the audience may be familiar with the Finnegan-Henderson firm. It's a pretty large boutique patent firm. And essentially what happened in this case is Mr. Chris Mailing, he sued the Finnegan-Henderson firm after obtaining patent protection for a number of patent applications he filed through their Boston office. In doing so, he basically said the DC area office of Finnegan had a conflict of interest because they, through other lawyers of the firm, represented a competitor of his called Masunaga Optical in also obtaining patent protection. So again, he gets patent protection, as does a competitor of his. Everyone's happy? No. Somewhere along the lines, he tried to get some opinion letter or something of that nature from Finnegan, and Finnegan says no. Ultimately, he learns that he believes that they had a conflict of interest and sues them. Ultimately, the court said, so the lower court found in Finnegan's favor, and then it was pulled up to the Supreme Judicial Court. And ultimately, what the court said was, although subject matter conflicts in patent prosecution may present a number of potential legal, ethical, and practical problems for lawyers and their clients, they do not, standing alone, constitute an actionable conflict of interest that violates Rule 1.7. That is interesting. I think there's a gift to patent attorneys, especially in Massachusetts. But what I thought was the biggest takeaway was that the court also recognized that law firms run significant risk, financial and reputational, if they do not avail themselves of a robust conflict system adequate to the nature of their practice. So ultimately, what I take away from this and explain to, especially to patent law firms, is you really need to be cognizant of subject matter conflict checking system. And it's not about, oh, well, I checked the subject matter conflict at the outset of the representation. It's a continuous process. And I'll give you an example. Especially when it comes to smaller independent inventors, smaller companies, a client or client representative comes to you and says, here's the disclosure. You look at it and it looks like ABC. You begin drafting the patent application. You've renamed the title of the invention. You've also clarified a couple of the terminology and made them more appropriate to how the vocabulary should be used with the USPTO, or you've used the definitions in the specification and change them up. Then you go and update the subject matter conflict checking system, right? Because now there's more information. It may have changed to now describe a broader reach. So instead of ABC, it's ABCDEF, right? It is really important to continuously update that conflict checking system. Another area of concern is things like office actions, right? I talked about this a little earlier, and I implied that if one client's application is cited against another client's application in an office action, that creates a problem. And the answer is yes, it is a problem, but why is it a problem? Well, as I've alluded, one of the biggest issues that we have is that when you are responding to that office action, you are explicitly going to say client A's application is inopposite because. And even if client A didn't care, the fact that you're making that decision for them is the problem. With informed consent, you would probably be able to do this, but otherwise, it is definitely a problem and very much likely a conflict of interest. Same thing happens when you're doing a search, or even more important, when you're doing an opinion letter. And Virginia Legal Ethics Opinion 1774 is actually very instructive. In this one, actually, I laugh because I think it's very interesting. A young associate asked this committee if there would be a conflict of interest if they were doing a validity or invalidity opinion about another client's patent. So in this case, is an invalidity opinion. And what happened was they started working on it. And later, the associate realized that the other party, the patent holder, was actually a current client of the firm. The associate goes to the partner and the partner says, it's not really a conflict because we've already started working and our client that we're writing the opinion for is going to be impacted negatively if we don't finish this opinion. And, we're going to end up losing some money on this. So just go ahead and finish it. And the ethics committee said, nope, that is a clear conflict of interest. It's not necessarily A versus B, but there's a material limitation element there. That's really what the subject matter conflict system is all about. Another type of conflict, really, I wouldn't necessarily call this a subject matter conflict per se. This is really side switching, but it's done in such an odd perspective. This was a case from the Northern District of Illinois, and I believe this was Barnes and Thornburg had essentially moved to both sides of the V through some mergers and acquisitions that the firm had engaged in. And what the court said was the letters that they had written to negate willfulness for some cable hanger patents that Andrew had. So basically, Beverly hired Barnes and Thornburg to write some opinion letters to negate willfulness against the Andrew cable hanger patents, and Beverly couldn't use them because what ended up happening was Barnes and Thornburg ended up being on both sides. And the court said lawyers, first of all, the general counsel of Barnes and Thornburg said something like, hey, the lawyers never talked to each other. Everything was fine. The court said, I think it's Judge Holderman in Illinois said, nope, that's not the issue. The issue is the firm's attorneys took positions that were directly adverse to their client. And that was improper, both violated local rules as well as the rules of professional conduct. And they likely had access to information to determine that this was improper, and therefore they shouldn't have done it. And therefore, the firm was disqualified under the imputed conflict rule. The end result was that the client could not use the opinion letters to negate willfulness, which likely created some sort of damages for the client. I didn't follow up to see whether there was any ethics or malpractice issues with this case, but definitely something to be mindful of. So in kind of closing up the loop on conflicts of interest, I think it is helpful to understand, one, did you identify the issue in advance? And why is that so important? Well, I keep asking that. I keep saying, hey, did you see it in advance? Why? Because sometimes certain types of conflicts are thrust upon you and maybe were not ordinarily visible. Sometimes that's important to understand at the outset. Second is one client a former client? And the reason is because of the difference between Rule 1.7 and Rule 1.9. The former client conflict standard is different and let's say is easier for you to navigate. The next question is, how can you address it, right? And that's connected to, is it clearly erroneous? Let's say the examiner cited the wrong application and it happened to be a client of yours. That could be clearly erroneous. But otherwise, what's the way you would address this appropriately for both clients? Is it a material limitation, etc.? And then, of course, can you get consent, right? Can you get consent from both clients to make sure that it is appropriate? Not only just because can you get them to say yes, but is it appropriate for the client in that specific situation, right? And one small thing I haven't really talked about yet is outside counsel guidelines. For those of you that work with larger companies, you may have outside counsel guidelines that tell you everything about who's allowed to bill, how much you're allowed to bill, what you can do, who you have to notify, who's going to sign the conflict waivers. Those are all really important. I mean, I can tell you outside counsel guidelines are the bane of my existence because I'm constantly helping lawyers understand these outside counsel guidelines and how they might impact their ability to do things for other clients. So a side note for some of you that might be in-house counsel, right? A lot of in-house counsel tell me, well, I cannot engage in conflicts because I don't have any clients. Well, that's not true, right? Conflicts of interest apply equally to in-house teams. And I'll give you this example of Charlotte Rutherford. She was an attorney at Schlumberger, a multinational, for about 7 years, working as a patent lawyer. While there, she evaluated, I think some invalidity opinion or something about Petrol, which is an oil well mapping software. And it included something called a 319 patent. Well, later, Ms. Rutherford left and went to work for Dynamic 3D Geosolutions, which I believe was like an NPE, and I think it was a subsidiary of Acacia Research. There, she was involved in the decision to bring a lawsuit against Schlumberger, again, her former employer. She ended up hiring the law firm to engage in that litigation. That was a problem, right? Of course, like any good lawyer, the lawyers for Schlumberger argued, hey, we need to disqualify her. And a lot of you are thinking, well, how can you disqualify an in-house counsel? Well, it's very easy, right? The court ended up dismissing the case as well without prejudice, and the Federal Circuit agreed. Well, what happened was the court said that the plaintiff's law department is treated like a law firm under Rule 1.10. Okay, so under Rule 1.10, they said that the law firm, which includes a legal department, the definition of law firm includes the legal department of a corporation or other organization. And that was important because that meant that Schlumberger was able to get not only Miss Rutherford, not only her in-house team, but also that the outside law firm that she hired disqualified. And ultimately, the Federal Circuit and District Court said you can refile the case, but without the fruits of her unethical labor. So again, it may have been more of a procedural dilemma, but it ended up resulting in a published opinion at the Federal Circuit dealing with conflicts of interest that impact in-house teams. I've seen this a lot, especially in the IP field. I get calls every once in a while saying, hey, Emil, we'd like to hire you to help us analyze this transition of this client from our direct competitor, and we want to hire them to be in our IP team. And I usually say that's the worst possible idea because other than the ethics rules that are applicable and the screening, trade secrets, Rule 56, those are all really problematic that you may not want to hire, unfortunately, the best person for the job, because the best person for the job is basically somebody that's at your competitor that could be at risk of being accused of taking confidential information. So some of the questions, some of you will chuckle when hearing this, some of the questions that I receive about conflicts of interest and how to navigate them this is a very popular one. If we just have separate teams, can we get around the disclosure and waiver requirements? And let me explain that to you a little further. So sometimes clients will come to me and say, we don't think that we have to tell our clients that there's a conflict of interest because of X, Y, and Z. And what I told you earlier was that itself is the conflict. So they'll say, well, your advice is to get a conflict waiver and have separate teams. What if I just have separate teams? Doesn't that mean the same thing? And the answer is no. Why? Because Rule 1.7, which is the rule that talks about conflicts, specifically has a paragraph B, which says, even with a conflict of interest, you can do so if you do A, B, and C, in basically 4 numbers. The last one is 4, which says each client gives informed consent confirmed in writing. Very simple, right? Well, you say that it's not the same lawyer. Well, if we go back to what we talked about with the Schlumberger case, it says, while lawyers are associated in a firm, none of them shall knowingly represent a client when any one of them practicing alone would be prohibited from doing so by Rule 1.7. So if one person has an obligation to disclose to the client, anyone at the firm does as well, regardless of whether you put a screening position in place. Screening generally is not in the rules for Rule 1.7. It's actually a former client conflict rule, and it's often used to help alleviate the concerns of clients, right? It's really an accommodation that you do to say, hey, we'd like to engage in this, waiver, and just to make things easier for you, these are the steps that we're going to take. All right. Oops. Sorry, it looks like it keeps going back. All right, here's another great one. If we have a less productive client, can we help them move to new counsel when we have a new client that approaches us? And the answer is yes if it's the first part, but no if you add that last clause. You're always free to fire clients, but you cannot fire a client simply because you have a more productive client in the same field that would ordinarily create a conflict of interest. So if you find a new client and it presents a conflict that you need to go to waiver for, get the waiver. If you don't want to get the waiver, don't drop the other less productive client, because that's what we call a hot potato that is improper. However, there might be situations where it might be thrust upon you. And that's why we kept talking about foreseeability, right? It says unforeseeable developments such as changes in corporate and other organizational affiliations might create conflicts, and it may be appropriate for you to withdraw from one of the clients. It doesn't say which one. You may be allowed to choose that. However, if you are the one that created the conflict of interest, don't try to rely upon this rule, right? What I mean to say by that is sometimes law firms are involved in the transaction. And if you are, like in this case, Truck Stop is the case involving Jones Day. Jones Day was involved in that transaction and couldn't then say, oh, well, I didn't know about this. But why is this really important? Because in both patent and trademark, we have a lot of multinational companies or companies that are often going through mergers, acquisitions, divestitures, joint ventures, etc. So these corporate family conflicts often come into play. And speaking of entity representation, it is important to understand who your client is, right? Do you represent just that one entity, or the parent organization, sister, child companies? Think about who's paying your bills, right? What does the contract say? And then, of course, what do the outside counsel guidelines say? Do they say that you are representing, everyone in their 10K? That is really, really important. And again, another case to look at would be the Dr. Falk Pharma case. That case really talks about how, unfortunately, you could have unintentional clients that basically prohibit you from having representation against people that are affiliated with that company. So definitely encourage you to look not only at your engagement, but also outside counsel guidelines. So I know we're running out of time here. I want to kind of quickly get through the signature issues. The signature issues, really, the USPTO has been very critical of practitioners making sure that they sign documents. It sounds very pedantic, but I will tell you that they've been very picky. We all know that very few people actually use handwritten signatures, but if there is a handwritten signature, put it in by hand. If it's asking you to type it in, personally type it in, right? It's non-delegable. If it's a client signature, it must be signed by the client. If it's the attorney signature, it must be signed by the attorney. A paralegal cannot sign a client signature, cannot sign an attorney signature. Likewise, an attorney cannot sign a client's signature. And the USPTO, specifically OED, has alleged that if you engage in some sort of signature violations, that you're violating 18 USC 1001, violating 3.3, candor to the tribunal, Rule 11 violations, which are 1118 at the USPTO, and that you may be an incompetent, etc. It's very salacious, but at the end of the day, just something to be mindful of. There is an example of In re Meikle, which is a really interesting case. This gentleman, I believe, was pro se, and I think that's maybe why the sanction was pretty high. Essentially, it was an attorney that owned a paralegal services company. He had managerial authority, supposedly, over these paralegals, even though they were basically sent off to do paralegal services for other trademark attorneys. The attorney relied on consent from the signatory and then permitted, apparently, these paralegals to sign on behalf of those other attorneys in 35 trademark filings, and ultimately was given a reprimand. Obviously these cases are from a long time ago because I try not to speak about cases where I defended, but here are cases, I think pretty much all of them were probably pro se, if I'm not mistaken, but they all had varying sanctions from reprimands to exclusions, etc. So unauthorized practice. So first of all, a lot of you are like, well, why are we talking about unauthorized practice of law? We're all attorneys here. Well, one, again, you're permitted to practice law before the USPTO. However, it also includes UPL for those who are assisting other lawyers, right? So we had talked about our duty of supervision, but let's talk for a second on the next slide about 11.505. A practitioner shall not practice law in a jurisdiction in violation of the regulation of the legal profession or assist another in doing so. Essentially, don't allow other people to use your license, to sign documents, to advise clients, etc., hand in hand with supervision. So UPL is also when you assist another in doing so. And just like we talked about this case just a moment ago, dealing with signature issues, a really good unauthorized practice case dealt with in Ray Shah. She pronounced it Shah, but basically a patent agent was representing applicants in trademark matters for the USPTO and providing these legal services, mostly from applicants from China. And while outsourcing is specifically permitted by the rules, and we'll talk about foreign applicants in a second, in this case, it was inappropriate because Ms. Shah was unauthorized, was not authorized to practice trademark law before the USPTO. And I apologize that I'm rushing through this. I will tell you that this is a really important thing for us to talk about. It is very customary for US patent lawyers when dealing with foreign clients to have some sort of intermediary, right? They act as a cultural and language liaison. However, the USPTO has been very cognizant of that relationship. And even though there's an official Gazette notice that says, hey, this is okay, but you must know that the owner and applicant has consented after full disclosure to be represented by liaison. This is in an official Gazette notice from the 1980s. What we want to make sure is that lawyers pay attention to what's going on, right? The USPTO is looking at who's signing the documents, the volume of filing. So if you're a trademark attorney that files 20 trademark applications a year, and all of a sudden goes to 20 applications a day, that is going to be a big problem, right? They're going to say, oh, well, you're not engaging in this careful review and blah, blah, blah. You may not have been doing that on a regular basis. Hopefully you were, but they're going to hunt that down and say, well, you filed these too quickly, or you did X, Y, and Z. And unfortunately, right now, a lot of applications from China have a big target on their back at the USPTO. They're really cracking down to make sure that, it's a sheer volume issue, right? The USPTO is going to collect the money, but then say there's a problem with the application and try to terminate the proceedings. Obviously, there's been a recent case, Chutter v. Great Management, that limited some of that authority in very limited circumstances. But so far, there haven't been a lot of people that have fought back on those issues. So definitely foreign filings, especially from China, are currently seen by the USPTO as de facto problematic. And it's up to you as the attorney to prove otherwise. So a couple final thoughts. I think it is really important that when you are working with foreign clients and associates, make sure that you have a good engagement letter, right? A lot of you will say, well, I never talked to the foreign client. And I think that's the problem. The USPTO identifies that as the problem. But in order to get around that, have an agreement that's sent to the client, right? Define who the client is, who speaks to the client, say, oh, this foreign associate is speaking for you. This is what happens once we get the office action. Who's responsible for paying? What we're not going to do. What we're going to do after the mark registers or after the patent issues. Who's paying for the maintenance fees? Those sorts of things. But beyond that, have a separate agreement with the foreign associate or foreign intermediary, right? Want to see what the relationship is between the two parties, what you expect for them to do. And then obviously they should have an agreement with the foreign client themselves. There really should be 3 agreements at least between all the parties that are involved in these sorts of situations. And I think, one of the biggest things to be mindful of is the USPTO is really hyper-focused on volume. So again, even if you're doing this on the US based level, it's really important to seek out quality work rather than quantity-based work. And again, I realize that a lot of you will say, well, I'm never going to go for quantity-based work. I'm always going to go for the highest price. And I often see that people don't understand what happens when somebody contacts them. Somebody will contact them and say, hey, can you sponsor me and I'll help you prepare 10 trademark applications a day. That's very reasonable. It'll take you 10 minutes each. Well, the USPTO is going to say 10 minutes is not enough, even though it may be enough for the average trademark attorney. The USPTO hasn't said what is enough, but they'll clearly say 10 minutes is not enough for your review. But they'll also say, well, you gave them access to a sponsored account, which is improper. So I also want you to consider, if you're engaging in such conduct, talk to an ethics attorney, but also look at things like the ethics rules, the substantive rules, but also the verified account agreement. The verified account agreement on the patent side is very different than the verified account agreement on the trademark side. And I know we are out of time, but I really appreciate you taking the time to listen. And if you have any questions, feel free to drop me an email or give me a call. Feel free to reach out to me on LinkedIn, and our blog is www.ipethicslaw.com. Thank you so much.